Welcome to the Texas Public Policy Foundation's online live stream of the attack on the court and the hoped-for end of Roe v. Wade. I'm Joshua Treviño, the Chief of Intelligence and Research at the Texas Public Policy Foundation, and I'm joined today by my friend and colleague, Rob Henneke, who is our Executive Director and our General Counsel here at the Foundation. Rob, it's good to be here.
Great to be with you.
Well, I understand it's been a quiet week for the court.
That is slow. Some obscure legal rulings that nobody paid much attention to. No, actually, it's been a, wow, did that really just happen week at the Supreme Court? And I think it did. That's part of what we'll discuss today. We have this incredible announcement, question mark. So nothing has officially happened, although the court has signaled that at least it's highly likely that it will repeal the Roe and Casey abortion cases.
That's right. And the source of the signal is a cause of some concern. Let me press pause for an admin note real quick. For those of you who are watching us live, you do have an opportunity to submit questions right now on the screen. So go ahead and submit them. In about 15 minutes or so, we'll start to get to the viewer questions as we conclude or we move into the second phase of our discussion. But Rob, let's talk about how we know this. It's something very unusual in the life of the court. And we know that there was a draft decision from February penned by Justice Alito that explicitly overturned Roe and Casey. How do we know that?
Well,
why does it matter?
We believe we know that. In the first time ever in the history of the Supreme Court, you had a draft, an opinion that was leaked to the media that in Politico, Monday night, I believe, was published in a story that said that this was the draft opinion about what the court, in its yet unannounced opinion, was intending to do, or at least at one point, there was a majority of votes to do so, and that the end result of that would be the court was going to repeal the Roe v. Wade case. Now, to put that in context, really, and understanding a little bit about how the Supreme Court works, gives you an understanding of why this was such a significant event, really just why it's such a betrayal and a challenge to the very existence and integrity of the court. The Supreme Court is unique in being the judicial body. The court, the way it expresses itself, the way that it has always, I think, prided itself, had pride, has been in the deliberate, reasoned opinions, that the court speaks with the voice of the opinions that it publishes, and as a result has fiercely guarded all of the discussions and debate and deliberations, and has, that go behind the scenes to point only to the published opinion, the analysis of law, the legal interpretation as how the court expresses itself, where you have Congress and you'll have debates over bills, or you'll have, the policy and politics of the executive branch. No, the judiciary, the Supreme Court especially, was the one that was very mysterious in the way that they acted. And the way they did so is this process that's been exposed this week. So you have the Dobbs case, which is the lawsuit challenging the Mississippi law that prohibited abortions after 15 weeks. Mm-hmm. The case was accepted for review by the Supreme Court. And just real quick in context, the way the process worked is that you had the oral argument of the Dobbs case in November. And what happens immediately after argument of a case is the entire Supreme Court goes back into a back room and they vote right then on how the case should be decided. It's completely secret proceeding, but right after the argument, they vote on how the case should be decided. And then depending upon the vote, it's a 9-justice court. So 5 votes is a majority that decides the case. Then the senior justice on the winning side decides who's going to write the majority opinion. Now, if it was Chief Justice Roberts, because he's the Chief Justice in the majority, he gets to decide. And if not, the next most senior person that's in the majority assigns the opinion. So presumably, because it was a 5-4 draft opinion and Alito wrote it, that presumably he's in the majority and he was assigned the opinion. But it takes this incredible process to get from that vote after oral argument to the published opinion. And it really is an intimate discussion and debate that happens in the written word with the court. And this is part of why the confidentiality is so protected, because part of how the case evolves and the opinion evolves is in the back and forth, where the justice who's assigned to write the opinion will do a first draft, say, this is what I think it should read. And then he circulates it to the court. And remember, he's got to get 4 other justices to agree to the entire opinion or to the holding of the opinion. And so another justice who may be agreeing with the outcome may disagree with a particular section and say, Justice Alito, I'm with you in theory, but, I can't agree with this paragraph. And so you have revised drafts and back and forth to get a majority that can sign off onto that opinion. And then the opinion goes to the judges who are on the other side, the dissenting justices. They then get to write their dissents. They write their opinions as to why the majority is wrong. And then the majority usually responds to that, tries to correct it, or at least tries to address their argument. So all of that happens in confidence. And many times you have opinions that change over time as the justices are persuaded in their arguments or persuade in their arguments, which is why a draft in February that signals at that point in time that there's a 5-4 majority to repeal Roe isn't necessarily the final margin of victory or the final outcome. And really, the confidence that these are kept in is to preserve kind of the integrity of the final product that is supposed to be the only version that's ever made public.
That's right. And so we know one thing for sure. We know what this particular draft looks like, or what it looked like back in February when it was purportedly written. But there's a number of things that we don't know. We don't know who did it, and we don't know why it was done. And on the second count, it seems obvious there is some sort of a political calculus at work. Can you talk a little bit about what that might be, understanding that it's informed speculation at best on our part?
It's complete informed speculation, but within the context that this is the most personal betrayal that I think could happen at the Supreme Court, with the confidence that's put into this, the trust that's put into the court staff at keeping complete confidentiality of the behind the scenes proceedings. So think about it in that context. Think about, the motivation that would cause somebody to betray that history and that legacy of trust. To me, what that signaled to me was an act of desperation, a Hail Mary, so to speak, that the person that leaked this to Politico, which we know is a very left of center publication, this was the warning siren. The importance that the left has put on the Roe v. Wade precedent for nearly 50 years, the sacred calf that has become. This was a warning cry to the world to say, basically the last 50 years of the liberal strategy and policy making was about to be torn down. And this is an emergency situation to respond and to try to change this outcome before the opinion can be published and be made, binding opinion of the court.
It's an interesting defense, not least because, at least it's my understanding, and feel free to correct if I'm in error, but within the legal community on the left and the right, it's commonly understood that Roe v. Wade is regarded as a poorly reasoned decision, even by those who agree with it. The late Ruth Bader Ginsburg, Justice Ginsburg, very famously described it as effectively a bad decision. It wasn't done well, poorly reasoned, not really up to the standards of the court in almost any era. And yet here we have this very ferocious defense of it at the hint that it might be overturned. How do we explain that?
Well, I think too, in understanding the context of where Roe fits, where the issue of abortion fits. I mean, I really think that the only parallel is if you went back to segregation and you looked at the overturning of Plessy eventually in rejecting the separate by equal, and how the stain of segregation, discrimination in this country, was perpetuated by the court and allowing that to continue. In the same way, when the Supreme Court acted as a super policymaking, super legislative body in Roe, it inserted itself took away this issue from the public, from the states, from the legislatures, from the people in their elections, and purported to just decide this issue as a matter of policy once for all. And one of the things that Justice Alito in this draft opinion goes through is really how Roe was not so much a legal opinion as it was a piece of legislation. I mean, the 3-trimester framework that just came out in the Roe opinion was nowhere represented in the briefing of the parties of the argument. I mean, the court just like made it up. But it did so in a way that gave this massive national victory to the proponents of abortion, and really signaled, and I think began the era where the left saw the Supreme Court and the courts as the way for them to make policy. Really, in the shift that the left had away from the hard work and deliberative effort of legislation and policymaking. You think about the permanence of the Civil Rights Act and the Civil Rights bills of the 1960s, how they still exist today. Well, that takes a lot of work and a lot of effort. And what Roe signified, not just in codifying this federal protection for abortion, but also opened the door to the Supreme Court, to the left, as the home run super policy making opportunity for them. And that's continued to be the focus, where the left has seen the courts as the way to achieve policies and outcomes that they've been unwilling or unable to obtain through the election process, through the legislative process. And, one of the things that's so seismic about this week is the signal that that may have just been a complete failure for the left, that there is no legacy, that there is no longevity in their approach that's tried to take the shortcuts by going to court or going through the executive branch with executive orders and so forth, regulatory fiats, that after all of that, when the dust settles, there just is not going to be any longevity in their efforts. And I think completely changes the trajectory of policy making for the next maybe 50 years.
Their efforts to end run politics and legislatures have made their decisions brittle, haven't they?
They have. It's taken a while. I mean, the other part to discuss in this context is you basically have this week being the culmination of the last 50 years of the conservative movement that really emerged out of the ashes of Roe and built the conservative movement for the last 50 years on the premise that someday we can end Roe and end the devastation that the decades of abortions have caused. That's been the argument that's led to the elections and the energy of the grassroots, and always the promise of, like, if we could just win one more election, if we can just nominate one more judge, if we can just have one more, we have the House, now we have to take the Senate, we've got the Senate, now we have to take the White House. I mean, it's been decades of these promises that's always been premised on, if we can just get to this point, we can finally win. But that was always an open question. And so this year, we got to that point with the culmination of everything, with the Trump presidency that then allowed for a majority of conservative justices on the court and the elections that led up to that, everything built to this point. But then had the case, presumably gone the other way, I think it could have been a complete repudiation of the last 50 years of the conservative movement. Instead, you have potentially an enormous victory that really validates the blood, sweat, and tears of conservatives and the grassroots through the good and the bad of more than my lifetime.
Just a reminder to our online audience, if you have questions, go ahead and enter them now, because we are about to move to viewer questions. But before we do that, Rob, let's look at the other side of the political equation and talk about the progressive movement in the United States. I'm very interested in this thesis of a prospective reversal of Roe in 2022 being analogous to, say, Brown versus Board of Education, which effectively undoes generations of societal inequity that a preceding court actually helped create and implement. What happens to the progressive project if Roe is overturned and we go back to an era of true federalism in which the states and politics in the states, properly understood, decide these matters?
I think if Roe is fully overturned, really the left has to start over. But I see that is a new chapter in our country and a great opportunity for the United States of America, for the idea of federalism, which is recognizing that states properly should be the engine of policymaking, that we want states to be the laboratories of democracy, not the federal government, and that it's through the competition of states in enacting different policy that we, reflect the will of the people and also improve policy and society through state by state competition. To me, when Roe is repealed or when the Dobbs case becomes published and official, that's a signal to the left that the Supreme Court is closed to them as the super policymaker for the nation. And at a time when our Washington, D.C. is broken, Congress is dysfunctional and gridlocked, really now the only opportunity is to pivot back to the states. And now for the left to return to the states on a state-by-state basis to implement the policies that they advocate for. And with the federal government, with the judiciary no longer acting as the super decider, the super policymaker for the country, you're going to see real differences in states, state versus state, red state versus blue state, and so forth. That's going to be great for the country. And I think you're going to really see a migration of Americans as when there's a difference between the culture and the policies and the government of states, people will choose for themselves, where to go. You've already seen some of that in terms of the migration away from the high tax blue states like New York, Illinois, California, in response to the SALT tax cap.
Right.
But here even more so, if we don't have a federal government that's just deciding for everybody, then you're going to see the states then become the engines of policymaking and a real difference in what it's like to live in one part of the country versus the other. And that's a feature. We should embrace that because that is part of the design of the founding fathers in creating the United States of America.
We have some viewer questions coming in. We're going to turn to them now. Thank you. First one is there's an argument out there that, and you saw it inaugurated this week from the left, this idea that if Roe is to be overturned, then the Democratic Congress in Washington, D.C. ought to go ahead and codify it via federal law, set aside whether or not they have the opportunity to do that, which is not realistic on their part. But there's a counter argument from the right that a Republican Congress, which is likely forthcoming in 2023, ought to do the same thing, to codify pro-life legislation at the national level. Is that a fruitful strategy in light of the opportunities for federalism?
It's not. It is absolutely the wrong approach, especially by conservatives and the right. I know the left will continue to want Washington, D.C. to be the national decider for all decisions policy, even though the Constitution limits the federal government to the powers, the limited enumerated powers set forth in the Constitution. But absolutely not. I mean, we've just spent 50 years fighting over judicial fiat in terms of the policy area of abortion. It's crazy for me that some Republicans want to then just shift that over into a different branch of government. Look, there is no constitutional authority for the federal government to regulate abortion, period. It's not within the enumerated powers. It's not something the federal government should be involved with. I mean, Justice Alito does discuss in his draft opinion about how this returns to the states then to be the arbiters of this on a state-by-state basis. So, we should reject any continuing federal involvement on this issue as being outside the bounds of the power of the federal government. And anyone from a right of center perspective should absolutely reject Congress from trying to insert itself and take on a role in this area. This is squarely outside of the authority of the federal government.
Obviously, none of us, thank you for that user question. We'll go to another. Obviously, none of us have the ability to dictate what the Supreme Court undertakes, which is a shame because we do a good job at it, you and I. But what do you think could be next in the vein of court decisions that just might send decision-making back to the states in fruitful ways?
Well, I would be a huge proponent of Justice Treviño.
Thank you. It's probably just you. So,
no, I think watching this and the continuation path towards federalism, I'm keeping a close eye on the West Virginia EPA case that was argued this term, and the decision will also here be coming out in a few weeks. And the question there was on limiting the power of the Environmental Protection Agency to use its powers to basically enforce climate change regulations, and specifically in the regulation of greenhouse gases and CO2. And it's expected that the Supreme Court opinion is going to be very destructive to the regulatory power of EPA to be able to advance a climate change agenda. Again, with that weapon taken away from the federal government, taken away from the Biden administration, it's going to even more so return the focus back to the states on a state-by-state basis to now really be the champions for environmental protection and regulatory type powers. But as you pull the power and authority away from Washington, D.C., then that's just going to return the focus to the states that are going to be able to show in terms of their respective state policies what works and what doesn't. And I think will really elevate the role of the states as being the arbiters of policy in the country.
Just a reminder, we stop at the hour, so get your questions in now. Another viewer question comes to us asking, is the genie out of the bottle? Is every Supreme Court decision from now on going to be leaked? Is there a permanent change in the way the court operates and thinks of its operations?
I think it's going to depend on how Chief Justice Roberts responds. I mean, again, to what I said at the beginning, this is such an incredible, enormous betrayal of trust that really threatens the integrity of the institution because of the trust that the justices have always had for each other, that no matter their disagreements, their internal deliberations would always be kept completely confidential. And that's a way that the court has been able to have relationships that have crossed over partisan ideology. Here in Congress, for example, you rarely would even catch today a Republican and a Democrat even being seen talking to each other. I mean, so, caustic is the partisanship there. But the Supreme Court prides itself on the way the justices can have collegial relationships, even when they disagree. The great relationship that Justice Scalia had with Justice Ginsburg, or the fact that Justice Scalia taught Justice Kagan on how to shoot a firearm, and how they had a collegial relationship even when they disagreed. If the trust is broken, then that collegiality becomes suspect as well. So going back to how Chief Justice Roberts responds to this, as the Chief Justice, he controls the timing of when the opinions are released. And my concern is the longer that he delays in publishing the Dobbs opinion, he really becomes complicit in this pressure campaign to try to get one of the justices in the majority to flip sides and change the outcome in the case and allow that pressure to build. But I think if Chief Justice Roberts were this week to publish the Dobbs opinion, make it final, make it settled, then that would take the court out of the current, state of protest and pressure and public affairs, and I think help to heal the court and to preserve its independence and integrity.
Let's drill down a little bit on the Chief Justice's options vis-a-vis the operation of the court. What disciplinary options are available to him, depending on who the leaker might be?
Really little. I mean, I think if it's an employee of the court, or if it happens to be a clerk, one of the young lawyers who works for a Supreme Court justice for a year, I mean, that person will be fired on the spot if they're able to be determined as the leaker. Now, if this happened, as I've seen some theorists kind of posit in the hypothetical, if a justice was involved in the leak, and there's really nothing that the Chief Justice can do. I mean, the power of Congress to impeach, remove a justice, which is just not realistic for that to happen. Yeah. Maybe the Chief Justice then, implements more protections, or, silos the information or something like that. But I think that will have a long-term negative effect on the court's ability to just communicate within itself. So really the best thing that the Chief Justice can do to rehabilitate this is to send a strong signal now that despite this betrayal, demonstrates that this action in no way will change the outcome of the case. And if anything, will even solidify the outcome. If I think the strongest message the Chief Justice could take, given the assumption that he's in the dissent on this case, would be for him to join the majority as a signal to show that he absolutely will not tolerate this type of betrayal.
In the 3.5 minutes that we have left, can I impose upon you to take a victory lap for the conservative legal community for how far this has come?
I hope so. I really hope so. I pray for that, that this leaked opinion becomes the final outcome. But it's the conservative legal movement and the conservative movement in a broader sense that has continued to advocate for the original text and meaning of the Constitution, that has continued to bring these ideas forward and debate them in the courtrooms, to debate the limits on government and the idea of protecting liberty, which is recognized as the primary purpose of government and enshrined in the Constitution. So for decades, the original conservative legal groups like Pacific Legal Foundation, Southeastern Legal Foundation, they were created in the late 70s by alumni from the Governor Ronald Reagan administration in building this campaign to ultimately eliminate Roe. And so, decades of work, decades of tireless efforts have kind of peaked at this point to even make this a possibility.
Last question before our last words. This can be a quick yes or no. Would we be here without Trump?
Absolutely not. No. I mean, this is the legacy. The argument for President Trump partly was, I'll elect conservative justices. And he delivered. And now the conservative justices, the Gorsuch, the Barrett, the Kavanaugh, that he nominated and got confirmed, could be the majority of the majority that ends up ending Roe. So for all of the ups and downs of the Trump administration, this by itself could be the historical validation of the success of his presidency.
Any final thoughts?
I'm watching to see really what next steps are. Certainly, personally, I'm celebrating if this becomes final, when this becomes final. But this just shows even more the opportunity that exists for conservative litigation, such that we do here at the Texas Public Policy Foundation, and not just putting government back in the box, but making that box smaller as we claw back the past 100 years of jurisprudence that have slowly eroded our constitutional rights. This shows how we can win major victories. There's more to the Constitution that needs to be restored in terms of our federal government. And then I think this just reinvigorates our efforts and our opportunity to take back this country and to return back to the idea of limited government and the importance of the rule of law.
And thank you, Rob. Very much
Thank you,
appreciated.
Josh.
One final thought from me, if I may. I'm not a legal expert, but I do know a little bit about politics. There's many of you who are watching right now who have labored in the fields of movement conservatism for a very long time. Some of you in the near half century since the decision of Roe v. Wade that we may overturn now. And it has been a long road, a hard one, with as many defeats as victories. But you should know right now, whatever happens, that your labors have paid off and your efforts have not been in vain. And victory in this, the most essential function of government, the protection of human life, is just around the corner. And that itself is a cause for celebration. I'm Joshua Treviño. Thank you, Rob Henneke, for joining us.
Thank you, Josh.
And thanks for supporting the Texas Public Policy Foundation.